Well, from pandemic disruptions to farm bankruptcy, 2020 was a big year for ag law developments, and we now continue our agricultural law year in review with none other than Roger McEowen with the Washburn University School of Law. That's what I get for trying to ad-lib. We'll stick to the list today, Roger. As we continue to move forward, it's no surprise that Dicamba Drift made your number 5. Let's start there.
Yeah, it sure did, Christina. Good to be with you. There have been, as a lot of your viewers and listeners know, a lot of cases filed in recent years that allege damage, particularly to soybean crops, as a result of dicamba drift. But we've had a major court decision in 2020 involving dicamba drift on a peach crop, Missouri's largest peach farm. And in early 2020, the jury returned a $265 million judgment against Monsanto, Bayer, and BASF. $15 million of that was compensatory damages for the farmer, and $250 million was punitive damages. Well, that went through the court system on appeal throughout 2020. The trial court did uphold the $15 million compensatory damage award on finding that the correct standard was used under Missouri law, and that there was an appeal filed in that case on December 22. That has implications for how courts look at pesticide drift cases beyond just dicamba, but that has been a huge issue, and that drift issue is going to continue to be big in agriculture in coming years.
That's absolutely what I was going to point out. This is one that will likely come up on next year's list as well. Coming into number 4 on your list, groundwater discharges and functional equivalency. Bring us up to speed on what happened there.
Yeah, this is a really scary one for farmers and ranchers and landowners across the country, because there was a Supreme Court opinion in 2020 dealing with the discrepancies between 3 U.S. Circuit Court of Appeals that had decided this issue in different ways in 2018 and then 2019. Well, in 2020, the Supreme Court said, well, when you have a discharge of a pollutant into groundwater that then seeps into a WOTUS, that might require a permit if that discharge into the groundwater is functionally equivalent to a direct discharge in a WOTUS. Well, Clean Water Act does not apply, does not cover discharges into groundwater. You're not supposed to have it to get a federal permit for that, because that's to be left up to the states. Now they've modified that a bit and said, well, if it's functionally the same as a direct discharge, then you do have to have a federal permit. Why is that a big deal? Just think of all the farm field tile drainage systems across this country and in the Corn Belt. That makes it easier for pollutants to enter a WOTUS, and they're prevalent in a lot of ag places, not only the Midwest, but California's Central Valley. So there are implications beyond just farm field tile drainage, but that is a huge, important decision in 2020.
Absolutely, and one that we're going to continue to watch as well. We are down to the final 3, so we look forward to covering those with you going forward into next week. Roger McEowen with the Washburn University School of Law, thank you so much for covering this top 10 list with us.